Good evening to everybody to the All India Bar Examination. It is the 17th Court 2022 and welcome to my today class of the virtual class, which today that I am going to deal the criminal procedure code. So please read what I posted on the screen. Anyone can unmute and read. Anyone can unmute and read what I posted on the screen. I repeat.
Sir, good evening. Sir, good morning. The students, sir, I unable to see, sir.
Yeah, that is yellow. That is at least read the below
one. Students of LLB final year, Professor Dr. Mohammed Saheb Hussain.
Yes, thank you very much. And without wasting the time, let me come to the point. All India Bar Examination, 17th Court, 2022, Criminal Procedure Code, multiple choice questions. Be ready. First question. Who is the father of Criminal Procedure Code? Option number 1, Sir Joseph Stephen. Number 2, Thomas Jefferson. Number 3, Sir Frederick Pollock. Number 4, Thomas Babington Macaulay.
The answer is 1, sir.
Yes?
Sir Joseph Stephen.
Wrong. Second choice. The right answer is Thomas Babington Macaulay. Or Macaulay, the way that you pronounce. Spelling is Macaulay. And he is that. Let me read the feedback. The feedback which I have given below is a Thomas Babington Macaulay. Macaulay was no mean historian of the England, though not of India. Anyone who knows the smattering of the Indian history should know about the Law Commission. There is a Macaulay was the chairman of 1834, the Indian Penal Code IPC, 1860, and the Criminal Procedure Code 1861. So these are the things which would be there. We can say that, yes, when you come to the matter of the second question is, for granting the pardon under the section 306 of the Code of Criminal Procedure 1973, the option goes in this way. Number 1, the witness must not be directly involved in the offense. Number 2, the accused should have been given an opportunity to cross-examine the person getting the pardon. Third, the person getting the pardon need not be in police custody. The fourth, the offense should not be punishable with imprisonment exceeding the 10 years. The question is, for granting the pardon, PARDON, under the section 306 of the Code of Criminal Procedure 1973, which condition is the right condition? I read the 4 options. Try your luck. There is no negative marks. Give the answer by looking at logically, by using the logical reasoning. Anyone? The answer is the third one. The person getting the pardon need not be in a police custody. So don't think that every time they will ask the easy questions. They may ask such a question also where you have to thoroughly read it. And if you turn the pages also, you could not get the answer. And merely it's a time consuming. Hence, my suggestion to my student is not to take any book or bare act in the examination hall. Now coming to the point, can anyone unmute and read what is the third question? Can anyone unmute and read what is the third question? I repeat, can anyone unmute and read what is the third question? I believe that you are hearing me. Pratap Reddy, Swati Sunka.
Sir.
Anyone can unmute and read what is the third question?
Question is not visible, sir.
Yeah. At least I have to hear from you that is visible now, it's visible that you are present or not, it will be known to me. Yes, now it is visible.
Yes, an order under section 319 of the Code of the Criminal Procedure 1973. 1. Can only be made on the request of the first information or one of the witness. Second, cannot be passed unless at least one prosecution witness has been examined. Third, cannot be made suo motu. Four, is an administrative order.
Which one is the correct one? Unless you read the 319, you could not be in a position to see. And that to be that you have to understand that total 319 section, then only you come to know that which is the real answer or correct answer. Here the correct answer is number 2, that is cannot be passed unless at least one prosecution witness has been examined. Then only the pardon will be made, otherwise it cannot be made. Is it clear? Said yes or no? Say yes.
Okay, sir.
Yes, I appreciate. So now the fourth question. Yes, I'm turning the page. The fourth question is compounding an offense under section 320 of the Code of Criminal Procedure 1973. Option 1 can only be done after obtaining the permission from the court. Number 2 can only be done by the complainant. Third, cannot result in an acquittal of the accused. Fourth, none of the above. Answer. Compounding offense. Section 320 of the Code of Criminal Procedure 1973. The answer is fourth one, none of the above. No one is correct. The answer is none of the above. The fourth option. So now let us go to the fifth question. If a judge dies, I repeat, if a judge dies after writing his judgment, but before delivering it, number 1, the judgment will be final as long as the judge has signed it. Number 2, the judgment will be final if his successor comes and delivers it. Number 3, the judgment will be considered merely as an opinion. Number 4, the judgment will be final in a criminal proceedings. Which among the 4 is the correct answer? Anyone? Quick. There is no minus marks. You make your hunch. I say anyone making a hunch?
Serial number 2.
Answer is serial number 3. The judge will be considered merely as an opinion because he dies after writing his judgment but before delivering it. But he did not read the judgment. So that is the answer. Sixth question. Can anyone unmute and read the sixth question? Can anyone unmute and read the sixth question? I repeat. Can anyone unmute and read the sixth question, which I highlighted, which I put it on the screen? I think it is visible to you. I have magnified also.
Judgment should not contain the name of the victim in case of a sexual offense.
Sound. I did not hear your sound. Increase your volume. You keep your smartphone near. Okay, other person. Quick. Why there is a problem? Is it your internet problem? Read. I said anyone can unmute and read.
A judgment, number 1, should not contain the name of the victim in case of sexual offenses. Number 2, includes an order of discharge. Number 3, must be written in the language understood by the accused. Number 4, in case of the acquittal, need not direct the accused to be set free.
Yes, which one is the right answer? Yes. You know,
Number 2.
a Delhi gang rape. Did they mention the name of the case law?
No.
But what what is the nickname of the case law?
Nirbhaya.
That means they did not disclose the plaintiff's name. Now look at the 4 options which will be the suitable for you.
Number 1.
Number 1 should not contain the name of the victim in case of the sexual offenses. That is the right answer. And 7th question, can anyone unmute and read? 7th question. 7th question. Anyone can unmute and read? Not same Pratap Reddy. Other people should have to come. I want to see that how they read and how their pronunciation is. Quick. Are you hearing me? At least you tell me. Or there is a problem of your internet. Or you don't know how to mute and how to unmute. Balakishan, please unmute and read the 7th question. Balakishan, do you know how to unmute and mute? I think it's a problem to him. Gauda Tirupati, can you unmute and read what I put on the screen? 7th question.
Sir, an appeal against the judgment of acquittal under Section Code of Criminal Procedure 1974.
1974.
Answers of yes.
Is it 1974?
1973. 1973.
Next.
First answer is not possible. Second answer, possible as long as made by the accused. Third answer, can only be filled by the
not filled,
public
filed.
prosecutor. Okay, filed. Can only be filed by the public prosecutor. Fourth answer, can only be made to the Supreme Court.
Which among the one is the right answer? Among the 4 options. Yes. Make a trial. Make a hunch. Anticipate.
Second answer, possible as long as. Second answer.
Wrong. Second option. Can only be filed by the public prosecutor. Number 3, can only be filed by the public prosecutor. That is the right answer. For the 7th question, the third one is the right answer. Can only be filed by the public prosecutor. Okay, let us go to the 8th question. The 8th question goes in this manner. In which of the following cases did the Supreme Court lay down the guidelines for premature release of life convict? Options. Number 1, Lakshman Asakar versus Union of India. Number 2, Boucher Perre Andre versus Superintendent Central Jail. Number 3, Kashmir Singh versus Union of India. Number 4, Raghbir Singh versus State of Haryana. Among the 4, which one is the correct answer for the Supreme Court lays down the guidelines for premature release of life convict? Answer is make a trial. No native marks. I would like to hear your sound. I would like to hear your answer. It will give the clarification to me that you are with me and I am with you. Anyone? Or if you don't know, you say pass on. At least say something. Say pass on.
Pass on, sir.
I appreciate it. It gives the sense that you are with me. Means somebody is listening to me. Number 1, Lakshman Naskar versus Union of India. That is the right answer for the 8th question. The next, 9th question. Which section of the CRPC? Which section of the CRPC? Just it is more. Overrides section 72 of the CRPC. I repeat, which section of the CRPC overrides section 72 of the CRPC? Options: number 1, section 78. Number 2, section 68. Number 3, section 58. Number 4, section 48. Among the 4 options, which is the correct options? The question, did you understand? It is overrides. Which section of the CRPC overrides the 72 CRPC? Say pass on if you don't know. If you don't know, say pass on. Anyone? Or give the answer. But you are supposed to speak.
Yes, sir, 78, sir, section 78.
Yes, section 78 is the right answer. First one is the right answer. Because it overrides the section 72 of the CRPC. If you happen to see the 78, it gives a clear idea to you. Okay, next, 10th question. What do you mean by pursuit? Number 1, authorizing the destruction of the corporation for the purpose of engaging in lawful enterprise, business, pursuit, or occupation is not restricted in meaning to a scheme for making the money, but includes any object consistent with the interest of the society. Number 2, authorizing the dissolution of the corporation for the purpose of engaging in any lawful enterprise, business, pursuit, or occupation is not restricted in the meaning to a scheme for the making the money, but includes any object consistent with the interest of the society. Number 3, authorizing the formation of the corporation for the purpose of engaging in any lawful enterprise, business, pursuit, or the occupation is not restricted in the meaning to a scheme for the making the money, but includes any object consistent with the interest of the society. Number 4, authorizing the reconstruction of the corporation of the purpose of the engaging in any lawful enterprise, business, pursuit, or the occupation is not restricted in the meaning to a scheme for the making the money, but includes any object consistent with the interest of the society. See, the 4 options that I read it in a one stroke. Not one stroke, with each one stroke, with a one breathing. Then which is the right answer? Sir, it is very lengthy. No, sir, it is very difficult to know it. Which is the right answer, because all the answer will not be seen on the screen. Sometimes they may ask in such a questions also. So one should have to know what is exactly the meaning of the pursuit, P-U-R-S-U-A-T, because whenever the cases are cited over there for the argument, it is only the persuasive value, but it is not a binding. But generally that one should have to follow it, because it is the Supreme Court judgment is there. It will be followed in the entire India by the lower courts. The right answer is the 3rd one. Authorizing the formation of the corporation for the purpose of engaging in unlawful enterprise, business, pursuit, or the occupation is not restricted in the meaning to a scheme for making the money, but includes any object consistent with the interest of society. Sir, it is a very long question, sir. We did not understand. Okay, make a trial, doesn't matter, because there is no minus marks. 11th question. Anyone can unmute and read what is the 11th question? Anyone can unmute and read what is the 11th question?
Appearance by public prosecutors comes under Section 301 CRPC, 2 Section 387 CRPC, 3 Section 280 CRPC, 4 Section 289 of CRPC.
Your voice is so low. Better I read it. Appearance by the public prosecutor comes under the number 1, Section 301 CRPC, Section 2, Section 387 CRPC, 3, Section 280 CRPC, 4, Section 289 CRPC. Which one is the
Section
correct answer?
301, CRPC.
First is answer.
Number 1,
Section
Section 301, 301.
CRPC.
It is the 301 CRP is the right answer. Section 301 is the CRP is the right answer for the 11th question. Okay, let us come to the 12th question. And I read the 12th question. A person is accused of the theft on one occasion and of causing the grievous hurt on another occasion. There are two occasions. Number one, theft, one occasion. Number two, grievous hurt in another occasion. Applying the section 218 of the CRPC, first option, A must be charged and tried for the theft and causing the hurt. 2. A must be separately charged and separately tried for the theft and causing the grievous hurt. Number 3. A can be charged and tried only for theft. 4. None of them.
True, sir.
Yes. Which one is the correct answer?
True, sir.
A must be separately charged and separately tried for the theft and causing the grievous hurt. Is it?
Number 1 is the correct answer.
A must be charged and tried for the theft and causing grievous hurt. That is the right answer.
Number 4 is the answer, sir.
4. None of them. None of them is the answer here. Okay. 13th question. In which of the following case a search warrant can be issued? Number 1. Where the court has the reason to believe that the person summoned not to produce a document or a thing. Number 2. Where the document or thing is known to be in the possession of any person. Number 3. Where a general inspection or a search is not necessary. Number 4. None of the above. Make a trial. A search warrant can be issued. There are 4 occasions are there, and which occasion is the correct one? Or you can say none of the above.
2, sir, 2.
Where a document or thing is known to be in the possession of any person. Not at
Documents
all.
of the third one, I think general inspection of such of not necessary. I
Not
think
at
2
all.
only, sir.
One, sir, one.
Where the court has a reason to believe that the person summoned not to produce the document. Can the person summoned to produce the document or not to produce the document? I intentionally put it there. When one place I removed the knot, another place I put the knot. To give the sense it is not correct. The right answer is not 1 is correct, 2 is correct, 3 is correct, none of the above. The right answer is none of the above. Yes, anyone can unmute and read the 14th question. Quick.
Service of summons on witness by post is covered under.
Read options.
1. Section 49 of CRPC. 2. Section 59 of CRPC. 3. Section 69 of CRPC. 4. Section 79 of CRPC.
Please, once you read it, you mute it. Otherwise, I am getting the resound.
Okay,
Gauda
sir.
Tirupati, mute. Mahesh Anand, mute.
Okay, sir.
Because once you read it, you have to mute it. Otherwise, no, I will get the resound. Okay. Now the option is, right option is
3.
here.
3
Out
is
of
the
the
right
4,
answer. 69 CRPC.
section 69 of the CRPC. The right answer is section 69 of the CRPC, where the service of summons on witness by post is covered under the section 69 of the CRPC. Okay, now the 15th question. The term victim, I repeat, the term victim is defined under the number 1, section 2, class W, section 2, class W, A small, section 3, third option, section 2, small u clause, and 4th, none of the above.
2, sir, 2.
Second one. Section 2.
2, section
WA.
2, within parentheses, clause WA, small letters. That is the right answer for the question where the victim is defined under the Civil Procedure Code. Another 16th question.
Sir, you underlined it with red, sir. That's why it's.
No, it is not underlined with red because it reads the spelling. Actually,
Okay.
I'd like to remove it. Actually, I have to make like this only. Now
Okay, sir.
it will be you have to use your any method, logical method, and try to give the answer. Sometimes using the logical method and giving the try to shoot it, it will directly hit the target. Now
That's why I tell true,
yes.
sir. I tell you.
Now you hit the target because of the advantage of the red line. Okay, let us see the 16th question. Section 162 of the Code of Criminal Procedure 1973 is for the protection of dash. Number 1, witnesses. Number 2, police officer. Number 3, magistrate. Number 4, none of the above.
One.
Do you think that it is for the protection of the 162?
Witnesses, I think.
Witnesses never be protected. Nor the police officer, nor the magistrate will come under it. None of the above is the answer. Because it will not say about the police officer as well as the magistrates also. So right answer is none of the above is the right answer. Yes, 17th question. Under the provision of the Code of Criminal Procedure 1973, confessions, and everybody knows. Number 1, can only be made to the authorized persons. Number 2, made to the police officer are valid. Number 3, yes. Number 3, made by the accused while in the police custody to a police officer is valid. None of the above. Yes, I made the confessions. 4 options is visible on the screen. Quick.
None of the above, sir. I think it
None
should be
of
given
the
in the
above is the
code.
right answer.
Yeah, it should be given in the code.
Because if you closely look at it, can only be made to the authorized person, not at all, because it's not showing who is the authorized person. Made to the police officer, no. A confession made to the police officer, not at all considered. And next, the third one is made by the accused while the police custody. No. When the police custody, they will interrogate him, they will show the revolver, they show the any other thing, and see that the confession should be made. So that's why we can say that the none of the above is the right answer. Of course, I modified it. Then I changed it in different sense. Because you know that if you make the police officer, it is not amount to confession. But a confession can be made only in front of the magistrate. Then only it will be taken into consideration. Is it clear? Say yes.
Yes. Yes.
Is it clear?
Yes, sir.
Yes, that shows your presence. That's my point. That shows that you are very much attentive. That shows that I can go ahead. Okay, 18th question. Can anyone can unmute and read the 18th question? Can anyone unmute and read the 18th question?
Which of the following sentences does not hold true for the confessions made to the magistrate under the provisions of the Code of Criminal Procedure 1973? Answers. First one, it is the duty of the magistrate to exclude the presence of the police officer from the place where the confession is recorded. Second one, it is obligatory.
I will read. You're taking a lot of time because time is less. Number 2, it is obligatory for the magistrate to warn the accused before recording his confession and that he is not bound to make it, and that if he does so, it may be used as evidence against him. Number 3, the accused should be sent back to police custody as soon as the confession is recorded. Number 4, it is necessary for the confession to be signed by the accused. Out of the 4 options, which one is the correct answer?
Second one.
The answer is third one. The accused should be sent back to police custody as soon as the confession is recorded. This is the which I cursor which I made it. This is the right answer. Okay, next, go to the next one. Which of the following confession is admissible under the provision of the Code of the Criminal Procedure 1973? I repeat, which of the following confessions is admissible under the provision of the Code of the Criminal Procedure 1973? Number 1, Magistrate, while recording a confession, did not specifically tell the accused that he was a magistrate. Number one. Number two, magistrate recorded the confession of the accused but did not get it signed by the accused. Number three, investigating officer took the accused from the jail to the magistrate, sat with him while the confession was being made, and brought the accused back to the jail. Number four, the magistrate recorded the confession of the accused but forgot to certify that the confession was taken voluntarily. It looks all alike, but there is a slight difference would be there, which is admissible as a confession.
I think first one, sir. Magistrate, while recording confession, did not specifically tell the accused that it was a magistrate.
So if he did not say it is admissible, a person who is taking the confession should have to make it clear that who is he. Can anyone come to you and ask, where is your house? Where is your address? You first, what do you ask him? Please show your identity card. Who you are? Who are you? Didn't you ask? Say.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
So which is the correct answer? The fourth one. The magistrate recorded the confession of the accused but forgot to certify that the confession was taken voluntarily, even though it is admissible. That is the appropriate answer. 20th question. And 20th question goes in this manner. Anna is accused of disobeying the direction of the law with an intent to save the Santosh from punishment. As per the section 213 CRPC, number 1, the charge must be set out the disobedience charge. Number 2, the charge must be set out the law infringed. Number 3, both 1 and 2. Number 4, none of them or none of the above.
2, sir. 2.
No. It is both 1 and 2. The third option is the right option. Both 1 and 2. The charge must be set out the disobedience charged. Number 2, the charge must be set out the law infringed. Because you are not misdirect the court, nor you have to hide any information of the accused to the court. If you does so, you are harboring the accused. Okay, 21 question. It goes like this. Which of the following states that no appeal shall lie from any judgment or order of the criminal court unless otherwise provided? Number 1, section 286, 2, section 287 CRPC, 3, section 388 CRPC, 4, section 372 CRPC.
1, sir. 1.
The answer is section 372 CRPC.
4.
The answer is section 372 CRPC is the right answer for the question. Now the 22nd question. Under section 32 subsection 1 CRPC for adultery, which section of the IPC is applicable? I say adultery. I did not say prostitution. For CRPC, when you are filing a case, and which section you can use in the IPC for the adultery?
468, sir. 2.
No.
First one, sir, 490.
No. 497. You use the 497 IPC when you are charging under the 320.
Adultery.
Yes, adultery. So next, 23rd question. A with 6 others commits the defenses of rioting. Commits the rioting, grievous hurt, and assaulting a public servant, enduring in the discharge of his duty as such to suppress the riot. Applying the section 220 of CRPC. Number 1, A may be separately charged with and convicted of the offense under section 147 and 322 and 149 of the Indian Penal Code. So 2, A may be separately charged with and convicted of the offense under section 147, read with the 323 and 150 of the Indian Penal Code. 3, A may be separately charged with and convicted of the offense under section 147 with the 324 and 151 of the Indian Penal Code. And the 4th, A may be separately charged with and convicted of the offense under section 147 and read with the 325 and 152 of the Indian Penal Code. So which one is the correct answer to file a case? Because this is the right
3, sir. 3.
It is the 4 is the right answer. A may be separately charged with and convicted of an offense under section 147 and 325 and 152 of the Indian Penal Code. That is 45 Act of the 1860. So that is the right answer for the question. Now let us go to the next 24th question. Can anyone unmute and read what is the 24th question? Anyone can unmute and
Guarantees of which article of the Constitution of India is violated by section 95 of CRPC? 1. Article 19(1) of A of the Constitution of India. 2. Article 19(1) B of Constitution of India. Article 19(1) G of Constitution of India. None of the above.
which one is the right answer? And you know the 19(1)G is a profession. 19(1)B, what is what? But A, everybody knows, freedom of expression, speech and expression. It is none of the above is the answer. It is none of the above is the answer. It cannot be made.
Okay, sir. Okay.
Because voluntarily I changed the question to make you more confused. Otherwise, you can easily give the answer if I don't twist it. Okay, number 20.
True, sir.
25th question. Section 49 capital B of the CRPC states that the memorandum of arrest under shall be dash. Number 1, attested by at least one witness and who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Number 2, countersigned by the person arrested. Number 3, either one or two. Either one or two. Next, both 1 and 2. Which one is the correct answer?
4, sir. 4.
4 is the right answer. Both 1 and 2 is the right answer. See, if you closely look at it now, automatically your third sense says, yeah, this is the correct answer. Because you are trained.
Yes.
Not you are trained. I am training you in that way. So that I am leading to you to go to the right target and fire it there. So that was my intention. And I am making to train in that such a way. Now let us go to the next, another question, 26th question. With the intent to cause injury to A institute a criminal proceedings against him, knowing that there is not a just and lawful ground for such a proceeding, means falsely charged, and also falsely accuses B of having committed an offense, knowing that there is no just and lawful ground for such a charge. Applying the section 220 of the CRPC, number 1, A may be separately charged with and convicted of the two offences under section 208 of the Indian Penal Code. Number 2, A may be separately charged with and convicted of two offences under section 209 of the Indian Penal Code. Number 3, A may be separately charged with and convicted of two offences under section 210. Only section is changing, 208, 209, 210 and 211. Now which one is the correct answer? Only sections are changing.
2, sir. 2.
No. Second option.
3, sir.
No, it is the 4th is the right answer. 4th is the right answer. So now let us go to the 27th question. What it says. Yes, 27th question goes in this manner. A has in his possession several seals, knowing them to be counterfeit. And you know what is meant by seals? Seals means when you want to print the counterfeit coins, there is a basis there. That base is called seals. When you have the seals, you can print the counterfeit currency. Knowing them to be counterfeit and intending to use them for the purpose of committing several forgeries punishable under the 466 of the Indian Penal Code, applying the section 220 of CRPC, and which one is the right one? Here the seal also, both also. Number one, it is a die. Number two, it is a mohuri. It is a stamp. It is a signature. It is a facsimile. Okay, number one, A may be separately charged with and convicted of the possession of the each seal under section 473 and 471. Another section is 472. Another is 470. The other wordings are the same. A may be charged separately with and convicted of the possession of the seal under section 470 of the Indian Penal Code. So which one is the correct answer among the four?
One, sir. One.
One is the correct answer. A may be separately charged with and convicted of the possession of the each seal. Say each seal is a separate offense. Each seal is a separate offense. So under section 473 of the Indian Penal Code of Act number 45 of the 1860. So that is the answer for that one. 28th question. Which of the following cases held that there is no conflict between the section 107 and 145 of the CRPC? The words in the section 145 are mandatory, while the language of the 107 is a discretionary. Yes, which section says? In which case law says this is? Number one.
Two, sir. Two.
No, it is number one. Baljit Singh versus Bhoju Ghosh. In this case law, it is
Okay, sir.
decided. It is number one. It is decided. Baljit Singh versus Bhoju Ghosh, 1907, 35, Calcutta, 117. Now the 29th question. Recognition is, number one, an obligation or acknowledgement of the debt in a court of law with a condition that the debt shall be whole, valid on the performance of the stipulated undertaking. Number two, can anybody will unmute and read number two? Under 29th question. Quick. Number two, 29th question, option. Okay.
An obligation or acknowledgement of a credit in a court of law with a condition that the credit shall be void on the performance of stipulated undertaking.
Yes, that is the second condition. Option. The third option is an obligation or acknowledgement of the debt in a court of law with a condition that the debt shall be void on the performance of a stipulated undertaking. And the fourth one is none of them above. Which one is the correct answer?
Four, sir. Four.
And third is correct answer. An obligation or acknowledgement of the debt in a court of law with a condition that debt shall be void on the performance of the stipulated undertaking. And the 30th question is, short title is the Criminal Procedure Code, 1973. And the long title is, I repeat, the short title of the short, not short, short. The short title of the Criminal Procedure Code, yes, still 5 minutes are there. The short title is the Criminal Procedure Code, 1973. And what is the long title of the Criminal Procedure Code? Number one, an act to be consolidate and amend the law relating to the criminal procedures. Number two, an act to consolidate and amend the rules and the law relating to the criminal procedure. Number three, an act to consolidate and amend the law and the rules relating to the criminal procedures. Number four, act to consolidate and amend the law relating to the criminal procedures.
Second one, sir. Second one.
No. Wrong.
Fourth one, sir. Fourth one.
No. Wrong. See, two options are there. Only two are left over there.
One, sir. One.
It is the number one is the right answer. An act to consolidate and amend the law relating to the criminal procedure. So that is the very right answer for the question which is given over there. So a question can be asked by any other way, by any other mode, in any other angle, because there is no hard and fast rule to ask the questions by the examiner. At that instance, you can make it out the way he wants it. At any corner, he can make it out. See, this question, I made it myself only. I don't think that you know, you got this idea that what is the long title and what is the short title. Because in the interpretation of the statutes, when you are reading it, there comes the internal aids and external aids. And where in the internal aids is, from the statute itself, we could know that what is the purpose of the statute, why it is made, what is the intention of the parliamentarian to make such a statute, and why it is enacted over there. So if you could not understand the short title at that time, we refer the long title. When you refer the long title, it gives a clear sense to us that yes, the purpose of making this statute to fill the gap of this is the intention, and this is the idea behind it to enact such a enactment. So when I'm making the short title, I made it like the Criminal Procedure Code long title. I made it myself, this one. And here that I found the short title and the long title, how it can be made. And I want to show you practically, but any time it can be stopped over there. Before it could stopped, I would like to show this thing. Of course, the PDF taking a long time to make it out. So let us go to the other way. Yeah, because it is the PDF takes a long time to open it. So just I want to show you what is the short title. Yeah, what is the criminal procedure Tanzania? What is the short form of the Code of Criminal Procedure? So here it may be given. The Code of Criminal Procedure, commonly called as the Criminal Procedure Code, CRPC, is the main legislative and procedure for the administration of the substantive criminal law. It has the enacted in 1973, and long title it is not given over here, but we can make it out. Criminal Procedure 1984. Oh, not. This will not be useful to us because this is a different title. Because we want the 1973 long title of the in Tanzania. Okay, anyway, that now the time is going to up. I would like to show it till it opens over there, because this is not opening. So every act, what I want to say is it's having the short title and the long title. So if you could not read out the short title, the main central idea, we can go to the long title to give the entire idea what is the intention of the parliamentarian to enact such a one. And of course, in the
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे